SJC-12477, New England Power Generators Association, Inc., v. Department of Environmental Protection, and another.
Mr. Jaffe, good morning. We appreciate all your patience. And now the time is yours.
As I said, all cases are important, but some cases are really important. I get that. Mr. Chief Justice, Associate Justices, may it please the Court. I'm Seth Jaffe for the plaintiffs' appellants. With me is Steve Bartlett. So our clients are challenging the legitimacy of regulations promulgated by the Mass Department of Environmental Protection and the Executive Office of Energy and Environmental Affairs under the Global Warming Solutions Act, called variously the 774 rules or the CAP rules. And those rules impose, and this is important, declining annual mass-based limits on CO2 emissions from electric generating facilities. And in my limited time, I want to address three issues, all of which make clear that the CAP rules are inconsistent with the Global Warming Solutions Act and would in fact increase statewide greenhouse gas emissions as defined under the Global Warming Solutions Act. So the issues are what we call the stack, the studies, and the statute. Very quickly before I start, though, I want to make clear what this case is not about. This case is not about a challenge to the statute or whether our clients support the goals of the statute or another regulation that is relevant and will come up in this discussion, the Clean Energy Standard. We are perfectly content with all of those. So why do we think that it's clear that the 774 rules can only increase statewide greenhouse gas emissions? The first point is that the logic behind the argument is simply irrefutable. I'll summarize very briefly how the market for electric generation works, but I would suggest that the Court could take a look at pages 7 to 9 of the brief.
Can I ask you about that? So
Yes.
the RGGI, how does it lower emissions? I understand there's trading allowed, but does it have a progressive decline for the whole region? How does that work?
So yes, that's basically what RGGI does. I will note, of course, happy to answer questions. RGGI is not an issue in this case, and there isn't a lot in the record about how RGGI works. But to answer the question, RGGI imposes a region-wide cap. That's the first R is, it's the regional greenhouse gas initiative. And it imposes limits which each state then has to implement because each state can only do what it does. Each state has essentially its part of an overall cap, and you get what are called tradable allowances. So I'm not sure if that's a sufficient
Well,
answer.
I guess my understanding of your argument is that 3C controls your industry, 3D controls everyone else. And the reductions from in your industry are going to be dictated by the RGGI or whatever you call it. Is that correct?
So, half to 90% right. So all I would say...
That's a good day for me.
All I would say, Your Honor, is that regulations under 3C are not necessarily limited to RGGI, but they have to be consistent with RGGI and like RGGI. Mm-hmm. And we would say that the annual declining mass-based limits in 3D are not RGGI, they're not like RGGI, and you can't call them 3C when in fact they are annual declining mass-based limits, which this court required under Kane for multiple industries, but not the electric generation industry.
But what do we do with the language of 3C, which speaks about emission levels and limits? 3C expressly mentions emission levels and limits shall be established, and it differs from D in that it says it shall be established by the Executive Office of Energy and Environmental Affairs and DEP, while D speaks only of the DEP.
Correct, Your Honor, but if it walks like a duck and talks like a duck, it's a duck. So the answer is...
I mean, but we'll leave ducks alone, but one says two entities must establish these levels and limits and is supposed to consider all these factors. And D says one entity is to establish. Now that seems to matter, and I assume somebody thought about that.
So, yes, but I don't think what that means is that it gives the second entity authority to do what the first entity can't do. So what it means is that the legislature understood that the electric generation sector was different. The Department of Environmental Protection just does environmental protection. There are separate Department of Energy Resources within the Executive Office of Environmental Affairs that understands energy markets. The legislature wanted to make certain that regulations that were imposed on the electric generating industry, took into account. So the language also talks about, taking into account the regional network. And the way they do that is by giving the authority in part to the Executive Office, which houses the energy expertise. But that doesn't mean that you can, under 3C, impose regulations which are really the province of 3D and which are inconsistent with the legislature's recognition that electric generation sector is different.
But one issue goes to authority, and so one of your arguments is that C does not permit there to be any limits established, correct?
It does not permit annual declining mass-based limits.
But I don't understand how do you interpret the language emission levels and limits associated with the electric sector shall be established?
So, for example, first, the other regulations that have been talked about in our briefs, the Clean Energy Standard, those were promulgated under Section 3C. They effectively implement limits because, by definition, if a certain amount of your power has to be renewable, that power cannot be fossil fuel power. More to the point, levels and limits can mean different things than the mass-based requirements of 3D. So, for example, and there was some discussion of this in Kane, the department can impose limits that affect emission rates, but emission rates don't impose a mass limit. And that's an important distinction. It was not sufficient to satisfy this court in Kane because 3D very clearly was about mass-based limits. But sometimes it's a better way to regulate. And so you can impose levels and limits that the department could impose more stringent emission rate limits on fossil fuel, on the electric generation sector, but they're not mass-based limits. And they would not pose the same problem. And I think the fact that they can do the one and not the other, again, reflects the legislative understanding of the difference between the regional electric generation market and what are effectively statewide industries, if you want to call them, such as building emissions. You can regulate building emissions in Massachusetts on a mass-based limit because you can't move a building to Connecticut. But if you impose a mass-based limit on emissions on a Massachusetts generating facility, those emissions can move to Connecticut.
I'm sorry.
Go ahead. No, go ahead.
No, go ahead.
You get all of this out of that one sentence in 3C that says, based on the regional, that all those restrictions are derived from that one sentence?
So it's more than that, Your Honor. And I'll be the third person this morning to say I had a holy cow moment myself.
Okay.
I think that the evidence in the record is important and actually is important in helping interpret the statute, even though it might seem backwards. I think that the legislature understood the distinction between the electric generation market, which is regional, and the other industries that would be affected by 3D, which were state only. And it understood exactly what the record shows. It understood that if they regulated the electric generation industry like other industries, you would get what this record shows you'd get, which is the study showing that if you impose a cap, the cap is either going to be useless or it's going to be bad. And they said, aha, or at least I said aha. I didn't say holy cow. I said aha. The legislature really got it. And sometimes we're kind of skeptical about what the legislature does, and we have to.
I'm curious, having some experience with the legislature got the ISO numbers. They projected into the future that that's how it would work. I mean, that would be quite a holy cow moment.
Yes, Your Honor. It's not so much the numbers that I said, but it is the sign, meaning plus or minus. I believe that the legislature understood that if you impose a mass-based annual declining limit on the electric generation sector, that you would get what's called leakage. There is the one line in 3C, but the statute defines leakage It defines it in a way that makes perfect sense, and I think it is a reasonable inference that the legislature understood that if you impose mass-based limits on Massachusetts facilities in a regional market, that what would happen would be those facilities would decrease emissions, but that generation still would have to come from somewhere and would come from out of state.
Can I ask a couple of background questions, facts? What percentage of the carbon dioxide emissions come from your sector?
So these numbers change over time, and I'm going to get this slightly wrong. It's now under 40%, and transportation's over 40%. It has been over 40. It was over 50 at one point. It may actually be under 30, but I think it's in the 30s at this point.
So roughly a third, around there, come from your sector. The RGGI ones, the RGGI structure contemplates some level of reduction regionally. Again, I don't fully grasp it, but you're saying that the legislature could not decide to put a mass-based reduction consistent with what's going on in the regional markets at the same time, given that you're a third of the problem? They decided to leave this to the RGGI structure and the 3D, clean energy initiatives?
So whether the legislature could do it and whether the legislature did do it are two different questions.
Well, but you need us under our standard review to sort of be unequivocally clear, or at least clear, right? Because if it's ambiguous, then we give some deference to the agencies, right?
I agree with that, Your Honor. You give a lot of deference to the agencies. But I think, in fact, A, the language is clear, and B, the studies back up that language, and they are just in sync in a way that I think you actually do have to credit the legislature for understanding.
Can I ask you one question about the studies? Because I think your brother's going to come up and say, the ISO numbers don't run sort of a dynamic model, that they leave certain things out, including the renewable energy. CLF says they also leave out that the other states are doing the exact same thing, at least a number of them in the consortium. What's your response to that?
So the response to that is it's just not correct. So if you look carefully at the ISO modeling, and I'll even give you a record citation, page 2396 of the record.
2396?
Yes. You can see that although the way the ISO framed their modeling didn't specifically say, here is the clean energy standard, one of their models included what are known as the 83C and 83D procurements, which I don't know that there's a lot in the record about, but you may have read in the papers. 83C is the procurement for offshore wind that the Commonwealth is in the middle of, 1,600 megawatts of renewable energy from offshore wind. 83D is a procurement for 1,200 megawatts of what is generally referred to as hydropower, but can be hydropower or onshore wind. That 2,800 megawatts of renewable energy is in one of the ISO models. That's far beyond what the clean energy standard actually requires. And in the model that the ISO ran that included the 2,800 megawatts of renewable energy, the ISO said, ooh, net statewide greenhouse gas emissions go up. They don't go up a lot, but again, if you're saying, you're looking at the deference that the agencies get, under a statute that is to reduce statewide greenhouse gas emissions, to my mind, if it's useless or bad, you can't start arguing, well, it's not that bad.
Well, but let me ask you a question about that. When you say they go up, does the model tell you how much they go up?
Yes.
And does it also reflect what would happen as the other states start to bring their facilities more into compliance with tighter rules, so that it might go up, but then it's going to level down at some point?
So I don't remember the exact number. I think under the scenario with the 2,800 megawatts, it goes up 86 metric tons. It's not a lot. I don't remember what the number was. It's got to be more than 86,000. I don't remember, but it's actually on this page, 2396. And yes, over time, those numbers will go down as the amount of renewable energy is provided. And that doesn't matter whether it's in-state or out-of-state, but what matters is the cap itself will never reduce 1 ton of statewide greenhouse gas emissions. The 774 regs at issue here, when you start getting all that renewable energy in the system, they become useless, but they never become positive. That's just the way the outcome is going to work.
So your argument is that it is arbitrary and capricious because with the purpose of trying to reduce greenhouse gases, these regulations will increase it.
Yes.
And now, that's a difficult challenge for you to show arbitrary and capricious. So what do you suggest we should do with regard to our review of the record that would demonstrate that, in fact, it's not merely, perhaps not the best solution, but that it's arbitrary and capricious?
So, Your Honor, there's a lot of deference, and it's a big record, but I actually don't think that's a difficult question, and it goes to what I said to Justice Kafka. Only the sign matters. If these regulations are either useless or negative, that's arbitrary and capricious. And in the record, the only evidence is that these regulations will, in fact, increase statewide greenhouse gas emissions. Everything that the Commonwealth says basically rides not on the 774 rules, but rides on the Clean Energy Standard. And they very carefully, in fact, do not analyze the impact of the clean energy, of the 774 rules, of the CAP rules. They say the Clean Energy Standard and the CAP rules together will decrease statewide greenhouse gas emissions. We don't challenge that, but there is no evidence in the record from which this court could conclude that, in fact, looking at the CAP will reduce statewide greenhouse gas emissions. And we don't ignore the Clean Energy Standard. That's really the response that I gave to Justice Kafka. The ISO included modeling that included this renewable energy. The modeling that the Commonwealth did only looked at the two together. All we suggest is, and it's not quite like an inference for somebody taking the fifth, but I keep coming back to that, it feels that way. They knew what our modeling was. The modeling showed an increase in statewide greenhouse gas emissions. Why didn't they model first the Clean Energy Standard and then the CAP rules on top of that to see whether the rules were symbiotic or hand in glove or all of the adjectives that they used? Because if you model the Clean Energy Standard first and then you model the CAP on top of that, you get to see what the impact of the CAP is. And they never did that. So their only modeling that they have in the record is the combined modeling. And the only evidence that there is in the record about the CAP shows that it will result in an increase. So that, to me, is arbitrary and capricious, Your Honor.
All right, and I'm sorry.
No, go ahead. I just have one. I was going to switch subjects to the sunset provision. Usually, you know, when you've got a winning argument, you devote more than a page or two to it. So I'm just trying to understand the sunset. You're basically saying all these regs that are bothering you, your view is they're sunsetting in 2 years, actually, you know, minus whatever we are. So why aren't you pounding that point, and is it more complicated?
I don't think it is, Your Honor, and I'm glad you asked since I'm out of time and otherwise wouldn't have gotten to it.
Yeah.
In fact, the reverse is true. The reason we didn't devote so much time to it is precisely because it is clear. But there's nothing that would prevent the legislature from going back and fixing it, and my view is that's what the court should say. If the legislature thinks it's a good idea to keep these regulations in, they know how to fix it, but it's for the legislature to fix. To me...
Your brother's going to stand up and argue that the sunset provision applies to 3D, and this is undertaken under 3C.
Right.
So what's your response to that?
My response to that is, it walks like a duck and it talks like a duck. So the department, these regulations only...
I'm getting lost in the ducks, though.
These regulations, it is worth actually reviewing the history very quickly. These regulations were originally proposed by the Department of Environmental Protection. Mm-hmm. A number of people, including our clients, commented and said, wait, these regulations, you can't do this past 2020. And then they came up with this idea that said, oh no, these regulations are under 21C and under all these other things, but these regulations are annual declining mass-based limits. I could just keep repeating that. That's what 3D says. You can't call it, I understand that they may have a lot of regulatory authority, but the authority specifically to impose annual declining mass-based limits is the authority in Section 3D. And the legislature said, we think it's a good idea if those rules expire. And I just want to note, because actually as clear as I think it is, we omitted it from our brief. The Attorney General talks about footnote 14 in Kane and all of this, but what they don't mention is literally the first paragraph of Kane says, and they're not Justice Cordy wasn't quoting the statute, he was just saying it, the department's got to propose regulations under 3D and they expire. I will say, Your Honor, if this court were to determine that the legislature gave the agencies authority under 3C to promulgate these regulations, and you find that these regulations are 3C regulations, then I would say that I would acknowledge at that point that they don't expire. But I think these are 3D regulations. That's why they're invalid right now. And even if you don't think they're invalid right now because they get so much deference you can't see it, they're still 3D regulations, and they would expire in 2020, and the legislature can fix that if they want.
Right, thank you.
Thank you.
Mr. Schofield.
Good morning, Your Honor. Mr. Chief Justice, and may it please the Court, Seth Schofield on behalf of the Department of Environmental Protection and the Executive Office of Energy and Environmental Affairs. I think I'd like to begin with the notion that there's absolutely no evidence in the record that shows that the regulations will do their job. I would direct the Court to page 3227 of the record appendix, and also the table at 3264. What this is a part of the agency's emissions study. And this particular section of the emissions study is an example of where the agencies tested some theories, in effect. They tested a scenario in which, and this again a hypothetical scenario in which demand for electricity is higher than the agencies predict, than ISO New England predicts. And what that model run shows is that in that scenario in 2018, the CAP regulations limit would constrain in-state power plant operations. As a result, it would reduce, and I think in our brief we indicated it would be 4%. It's actually slightly over 5%. That triggering of the cap would result in a reduction of in-state greenhouse gas emissions by approximately 5%. When you look more broadly, and this again is reflected in the text and in both the data, you see that while the in-state reductions would indeed be greater, you also have a net regional reduction in greenhouse gas emissions of about 1.7%. So it's simply not the case that there's nothing in the record that shows that and in the instance that the cap does constrain in-state power plants, it will automatically lead to greater overall regional emissions.
By the way, so this was a study, we're in 2018. Do we have, the record doesn't show whether that study proved to be accurate, I take it.
Well, it hasn't yet, Your Honor, and we won't actually know that until after the year is complete. And more likely, it may even take.
And is that true for the ISOs? Is the ISO also proved to be? We're in a realm of theory as opposed to, proven facts, right? The ISO model says one thing. Your model is the other model, right?
Yeah, and Your Honor, two responses to that. One, I think to your point, these are models, they are projections, and it's important to recall that the power plants here are asking the court to effectively strike down a duly promulgated regulation based on a hypothetical scenario. Not actual proof of what will happen, but hypothetical scenarios. And second, Your Honor, the models are actually quite consistent with one another. They do rely on some different assumptions that show some slightly different results, but the results in themselves aren't even that inconsistent. I think the important takeaway from the ISO New England study is that, as reflected in our brief, the ISO New England study actually shows that projected emissions are expected to be below the CAP regulations limit in every year. which means that the kind of the simple logic, the triggering of the cap and the shifting of electricity, it doesn't occur until the cap is triggered.
Meaning that the mass electric power plants will be fully engaged. They won't be sort of benched while we bring in the dirty or out-of-state.
That's correct, Your Honor. That's what the agency's emission studies show, and that's also what the ISO New England study shows. What ISO New England did, similar to what the agencies did in their own model, was test some alternative scenarios where the expected outcome is maybe not the actual outcome. And they test some more extreme situations. Even in that situation in the ISO study, it did show that that there could be some regional increase in greenhouse gas emissions, but again, that was only for 1 year. And it's
moving away from the models, because we're going to obviously have to digest them. So back to the statute itself. The chief makes a point about the emission language in 3C, reduction language. You don't really focus on that in your brief, do you? Do you have a reaction to that, or do you focus on it and I missed it because there's a lot of reading here?
Yes, there is, Your Honor, and part of that was because this is very complicated, we want to make sure it was understandable. But yes, that issue of the essentially the statutory questions is addressed in part 1 of our brief, and I think as your questions and Chief Justice Gant's questions went to earlier, there's no question that Section 3C authorizes the cap regulation here. The statute clearly speaks to both levels and limits. And here, the cap regulation is a limit. And a contrary conclusion, essentially accepting NEPCA's argument, and they acknowledge this in, I think it's footnote 8 on page 31 of their brief, that an in-state cap, they say, will necessarily fail under 3C. Well, what that means is that the agencies could never issue an in-state cap under 3C, but that's all Section 3C authorizes. So if their logic is correct, then the agencies could never do anything under 3C.
That's what I was asking your brother, because I'm trying to understand it, because if they're saying what you do has to be consistent with the RGGI. I thought they were going further and saying they had to leave it to RGGI, but there seems to be something they're allowing you to do on top of RGGI. Is that your understanding, or is it just the only way you reduce emissions for electrical generators is through RGGI? Is that your interpretation of what they're saying?
That indeed is our interpretation of what they're saying. They've pointed to the Clean Energy Standard, which established levels. Basically, how that works is it requires the people selling electricity in Massachusetts to sell an increasingly large proportion of that electricity has to be clean electricity. And they pointed to that as an example to give some, in response to the really troubling statement in their opening brief that there can't be an in-state 3C limit. But RGGI doesn't, as we've indicated, can't supply the limit. The court made that clear in Kane. I think what's interesting, and this is pointed out in the Conservation Law Foundation's amicus brief, is that we're basically seeing the same playbook rolled out again. The power plants tried to derail RGGI with the same leakage argument that they're trying to use now to derail the cap regulation. Now, ironically, they speak quite lovingly about the RGGI program. But the same issues are really directly in play at both, but they say in their opening a brief, abandoned in reply, that RGGI is okay because it minimizes leakage. Well, that's exactly what the agencies did here. They considered all of the issues in play. We acknowledge that leakage is a thing that can happen, but their obligation under the statute is to minimize leakage.
Does RGGI lower emissions, or I understand it has a trading program. Does it also have a multi-state reduction? Is that part of RGGI?
It works quite similarly, Your Honor. It establishes a cap and then uses an allowance system where basically a power plant has to have in hand.
Have a decreasing cap too? I'm
Yes,
just
Your
try-
Honor.
So this regional solution that's in place has a declining emissions requirement. And so how does then the Mass one work with that decline? So we're going further, we've negotiated a regional deal that requires us to lower, and you're saying that we've also imposed additional mass-based lowering as well? And that's consistent in your view with that sentence about this shall be based on the blankety blank?
That's that's correct, Your Honor. 3C.
Could you articulate that? Just tell, if you were writing the paragraph in the decision that said that, how would it read?
Well, of course, Your Honor, I would refer, our brief says it much better than I'll probably say it right now, but 3C does require the agencies to take certain things into account, recognizing that Massachusetts isn't here alone doing things. And one of those things the legislature said is the agencies have to take the Regional Greenhouse Gas Initiative and the Regional Portfolio Standard into account. How the agencies interpreted that to mean that they should, that any in-state cap regulation, like the cap regulation limit here, should complement and not undermine those programs. So they specifically—
How could you lower in-state emissions and contradict the Reggie one? I'm just trying to,
The issue is more about prices, Your Honor. It's about how a cap on in-state power plant only could affect the cost of allowances, that basically the price to pollute under the Regional Greenhouse Gas Initiative. And so the agencies were looking to make sure that a cap on in-state Massachusetts power plants would not unreasonably increase the costs of allowances under the Regional Greenhouse Gas Initiative.
could you explain a little bit how would that work? Just how would that happen? So give an example.
That's a harder thing to explain than you would think, Your Honor. Basically, if
You're going to want to explain it, because if you can't articulate it, good luck with us.
Yeah, so and so this is, I think that I would address this in a situation in which the in-state limit did restrict power plant emissions.
Right.
You could, some electricity does start getting shifted around a little bit. So some other power plants may need to purchase more allowances than they would otherwise have had to purchase under Reggie. And
So
that increased demand.
But is that playing into the ISO model that he's talking about?
Not necessarily, Your Honor, because,
Leakage model that he's talking about?
excuse me?
Does that play into the leakage model that your brother is relying on? That if we cut it too much, we're going to increase costs here because we're going to have to purchase from those dirty plants elsewhere?
Well, again, Your Honor, we acknowledge that the leakage is an issue, can be an issue. But what the agencies did here was they crafted these regulations to ensure that, under their modeling, and the ISO modeling agrees with this, there will not be any leakage.
Meaning they didn't reduce too much?
What they did is they established a cap that would be achievable in the real world, taking into account all of the other policies in existence. And I think this is a really key difference between what the agency's emissions study did and what the other studies did. They largely omitted the clean energy standard. And again, the agencies made this clear throughout the rulemaking that those two rules were promulgated together to work together. In effect, and I try to explain this, and there's one other issue I wanted to just get to.
But your brother says they did take into account the hydropower and the solar and the wind farms. So he's saying you're wrong, and I think he's saying you're wrong. But
Well, I think I heard him say that too, and that was the first time I've heard that.
Okay.
But we don't agree
So when
with
we
that.
look at those pages he's talking about, we're not going to find the hydropower or other forms of this sort of increase in these clean energy sources.
Yeah, sure, Your Honor. You will see in that table, and it's your eyes will get blurry staring at it for too long because there's a lot there. You will see that they did account for some additional renewable clean energy in their modeling. What we're saying is it didn't account for everything. What it didn't account for was the clean energy standard, which requires an increasing amount of clean energy to be sold in Massachusetts. What this means, and under the simple logic argument,
And I don't mean to cut you off, I'm just trying to understand it, meaning that they've projected some movement towards clean energy, but not this coerced movement that's being channeled in 3D or wherever it is?
that, and also that it doesn't project how the accounting for it works, where where more clean energy is being sold to Massachusetts, so less of that energy is coming from power plants that are emitting greenhouse gases. It's not a one-to-one displacement. I think that's the easiest way to understand it. If you reduce the ability of a power plant in Massachusetts to operate, the power is not displaced 100% to a new power plant out of state. And that's because of the clean energy standard says that out-of-state power that's coming into the state is not a one-to-one basis. Instead, for example, in 2025, 30% of that has to be clean energy, meaning no emitting, essentially zero or no emitting greenhouse gas emissions. So I think that's an important point. It's not this one-to-one ratio. The clean energy standard is designed to make sure that it's not a one-to-one ratio. And over time, by the time we get to 2050, it's 80%. So 80% of the power is coming from sources that aren't emitting anything.
The sunset provision, you say, okay, it's a 3D provision, not a 3C provision. Is that?
It's a 3C provision, Your Honor, and the record bears that out.
Can I ask, and can I ask, you seem to rely on the interrelationship between 3C and 3D in a lot of your argument, meaning 3D happenings, this cleaner sources of energy, helps make 3C make sense. When the regs sunset the 3D part of this, does this all work together in a sensible way?
I think what we were trying to do, and this may not have been absolutely clear, what we were saying is that in regard to this particular regulation, that it is absolutely authorized by 3C, but that 3D also supports it. Not that, I don't think we spoke directly to the interrelationship of any other 3D regulations. Like there were 4 other regulations promulgated at the same time, all designed to reduce greenhouse gas emissions.
They're all going to sunset, right? All those 3Ds sunset in 2020?
I don't believe so, Your Honor.
So what happens, what did the legislature expect to happen in 2020, and why something sunsets, right?
Well, I think, Your Honor, that the legislature, we indicated this in our brief, that it appears that the sunset provision is a holdover from the California law, which only went to 2020. So under the California law, everything sunset. There had to be new legislation.
It's a rogue derelict provision sitting out there that we shouldn't give any meaning to?
No, Your Honor, no, we're not saying you shouldn't give any meaning to it. What we're saying is the court should give the meaning that it gave it in Kane, which is in Kane in footnote 14, the court said, what this really means is that the agencies need to, its fundamental purpose of Section 16, the Sunset Clause, is to require the agencies to reevaluate the limits that they set before 2020, to make sure that the limits that are in place are still sufficient to meet the next limit, 2030, and to meet the limit after that, 2040, and to meet the penultimate limit of 2050.
So
everything works.
They don't sunset, it's just a redo, but it's not a sunset provision? It's a look back, but not a sunset provision?
Yes, Your Honor. And what we're asking the court to do is to construe Section 16 so that it's consistent with the purposes of the GWSA. And the purpose of the GWSA and the limits is to make sure that emissions decrease every year through 2050 to reach a dramatic result of 80%. And we've said this, and it's particularly important in the electric sector, which is maybe why the sunset provision doesn't apply to 3C, because a loss of 1 year has significant implications for how the markets work. We've said this in the brief, but again, for the markets to work correctly, there needs to be clear long-term signals so that investments are made today that will reduce emissions and decarbonize the economy by 2050. What is in the cap regulation?
I'm still going, I'm reading footnote 14 now. A more sensible reading is that the sunset provision exists because after 2020, new annual limitations on emissions would have to be issued to ensure that the statewide limit for 2030 blankety blank will be met. Aren't we saying you've got to do something in 2020?
Well, Your Honor, what we're saying is that an interpretation of Section 16 that's consistent with the statute and doesn't undermine its purposes is the one that we've suggested, which is that what Section 16 is really all about is a reevaluation of existing limits. But again, I repeat that the court doesn't need to even reach this issue because this regulation is a 3C regulation. If Your Honor, if I could just kind of sum things up quickly, if I may. I see my time's out. Would that be okay? Because
Very quickly.
I want to provide some kind of real-world context for this, and I'll build off something in Footprint's reply brief, which is a trench digging analogy. Maybe we'll end on a little lighter note. But that trench digging analogy is built on a false premise. It assumes that person A, the clean energy standard, is doing the same job as person B, the cap regulation. That's false. In reality, person A and person B are doing different jobs to reach a similar goal. Under that person A, the clean energy standard is digging the trench, while person B, the cap regulation is fortifying the trench's walls. But far from enjoying a lazy Sunday afternoon under the tree, the cap regulation, person B, is doing other jobs as well. For example, she is running around with a megaphone, waving her arms and telling people to invest in new clean energy resources. Second, she is serving as a role model for other states to further their own decarbonized clean energy futures. Third, she is passing Gatorade to person A, the clean energy standard, to make sure that person A can sustain her efforts to promote more clean energy. And finally, she is returning to the trench each year to fortify the next 2.5 feet of dirt. That is the greenhouse gas emissions that have been removed that year. And to the extent that person B, the clean energy standards efforts the cap regulations efforts cause a few hypothetical pebbles to fall back into the trench. And to be clear, that's really what we're talking about in terms of the leakage.
I guess I have one question, and then I think we're going to need to close. But if your brother is right, that upon the analysis, it turns out that since the Regional Greenhouse Gas Initiative and the Renewable Portfolio Standards already exist, that if the limits which you impose, looking at it through a marginal analysis, layering that on top of it, were to make things worse, would you lose?
Would we?
Would you lose? Should we apply what they say is a marginal analysis? That is, we should look to see what the world would look like without these limits, and then if you layer the limits on, they say, well, if you layer the limits on, it turns out that you're worse off than without the limits.
Well, that's not true.
If they are, I know, if they are right, do you lose?
No, Your Honor, because again, those are hypotheticals. What the record shows is that they happen in 1, maybe 2 years. It's very important to recall that compliance with the GWSA happens every 10 years, not every year. And so an increase 1 year, assuming that extreme hypothetical does play out, does not mean that we won't comply with the GWSA. And there are many reasons, there are 5 different ones, as to why the cap regulation does do a lot, actually.
Okay, well, we're going to have to rest on your brief for those 5. So
Thank you.
Thank you.